Hi, welcome to North State Law. My name is Nick Dogle, owner and founder. Today's topic is demystifying legal jargon. What does burden of proof mean? So we've seen this a lot on your typical court TV programs, court TV shows, legal shows, kind of things like that. And I'm going to give you the textbook legal definition that you're going to find in your Black's Law Dictionary, other legal dictionaries, things like that. And it's this necessity of affirmatively proving a fact or facts in dispute on an issue raised between the parties in a cause. So I'm going to explain a little bit what that is and break that down to kind of its bare bones form. And that's essentially typically you're going to have just two parties in a case. And we're just going to use plaintiff and defendant as an example, okay? So if one party is claiming somebody else did something wrong, and in this particular example, it's going to be the plaintiff claiming that the defendant did something wrong, they are going to have the burden of proof. They have brought something to the court that says, hey, I think this person did X, Y, or Z. Well, because you're accusing somebody of doing something, you're going to have the burden of proof. And that is the simplest form that I could break it down to. It is a little bit more complicated than that, but that's kind of the simplest way of explaining it. Now, you've got three different burdens of proof that are predominant in North Carolina, and those are going to be your civil burden, which usually, and I'm not a civil attorney, but I know clear and convincing evidence is a standard for certain causes of action. I think for certain other causes of action, they may use by a preponderance of the evidence, but predominantly it's going to be clear and convincing evidence. For your criminal standard, beyond a reasonable doubt, I think everybody knows that. The thing with beyond a reasonable doubt is it's the highest burden of proof that we have in this country. It's used for all criminal cases, only in North Carolina, but all over the country. And it's not been defined by a statute or by any case law. The U.S. Supreme Court has not defined it. No appeals courts have defined it. It is undefined. But it is by far and away the highest burden of proof that we have because we're dealing with people's individual freedoms. And therefore, it has the highest burden of proof when somebody is accusing somebody else of a criminal activity. So what are the other ones? So clear and convincing is going to be the next highest standard. I'm not getting into too technical definitions on this because I think I've done that a little bit too much already, but that's like your 70 to 75% burden of proof standard is your clear and convincing. And then you've got your by a preponderance of the evidence is going to be lower than your clear and convincing. That's basically 51%. More likely than not is what you would have to prove on that. Now, where it gets into play with administrative law, which is basically under where professional license defense falls under the umbrella, is they have both. They have clear and convincing, and they have by a preponderance of the evidence. So, if you are seeking to have a licensed be a licensed professional, and you go to your licensing entity, whether it's a state board or state agency, and they deny your licensure, you can appeal that, but you then have the burden of proof by a preponderance of the evidence to show why you should be granted that license and why the licensing authority messed up. So that one it makes a little bit of sense. To me personally, it doesn't make a ton of sense because you're talking about somebody's ability to potentially work and earn income after going to school and getting all the requisites done, passing exams and things like that. And if you're still denied, why should you really have the burden of proof? So it is what it is though, and that's the way that it's done in the state. So that's a preponderance of the evidence example. The one that really gets weird is under North Carolina General Statute 150B, Article 3, when we're talking about state agencies implementing fines or penalties. The way I read that portion of the statute that talks about burden of proof, I read it as the state agency has clear and convincing evidence standard, and they have the burden of proof regardless as to whether or not they filed a petition or the other side did, the licensee. Other people disagree with me and say, no, the other portion of that statute that says petitioner has the burden of proof by a preponderance of the evidence and flat out, and a lot of times what these state agencies do, they put in their admin codes that the licensee has to file a petition for a contested case at the Office of Administrative Hearings. Well, by doing that, they're dictating who has the burden of proof, and that would be the petitioner, in their opinion, and that would always be the licensee. So they're creating an advantage for themselves, which is why I don't agree with that, and I think that the very clear and convincing evidentiary standard that's laid out in that same section under North Carolina General Statute 150B clearly puts the burden of proof on the state agency, regardless as to whether or not they're a petitioner. And I think that's pretty clear, but like I said, reasonable minds can differ, and that's okay. So I hope that this was a pretty good explanation of burden of proof in North Carolina. If you guys got any questions, check out the blogs on my website. It's northstatelawfirm.com. You can also check out my other YouTube videos on my YouTube channel. And then also, if you can't find what you're looking for, please text or call 919-521-8810, and you can get a free 15-minute discovery call with a member of my staff. Thank you very much for watching. I hope everybody has a fantastic day. Bye-bye.